Can a victim of sexual abuse be determined to be at fault in a Pennsylvania civil case? My name's attorney Ben Andreozzi, and our law firm Andreozzi and Foote represents survivors of sexual abuse across the country and throughout Pennsylvania in civil cases against large and powerful organizations. We've been asked if a lawsuit can be dismissed or a jury's verdict reduced based upon the alleged fault of the victim. This is a very controversial topic because it's our opinion that victims of sexual abuse are never to blame. The good news is that in Pennsylvania, a minor can never consent to sexual contact with an adult. So in those situations, a victim's behavior will not be considered. The same can be true in a case that a victim brings directly against the perpetrator if there's a criminal or a civil finding that the victim did not consent. However, at least one trial court has determined that a victim's behavior can be considered in a case that's brought against an allegedly negligent third party. In that case, an intoxicated victim of sexual assault brought a claim after she was at a fraternity party and sexually assaulted in a hotel. It was ultimately determined that she was 7% at fault, and her overall jury verdict was reduced accordingly by 7%. In Pennsylvania, if a victim or a plaintiff's behavior contributed to 50% or more of the fault that is allocated, that victim can be precluded from making a recovery in a civil case. Now, defendants are always trying to point the finger at victims. We've been successful in exposing these tactics, and we find that they typically backfire against the defendants. If you're an attorney and you're interested in learning more about our strategies, please feel free to email us at info@vca.law, or to find out more information about the firm, you can visit our website, which is www.victimscivilattorneys.com.